And our second case will feature Professor Blackman. This case is the California versus Texas case. And in this case, the Supreme Court of the United States is once again looking at the constitutionality of the ACA, or the Obamacare Act. Josh, are you with us?
I am here. Welcome. Thank you so much.
Wonderful. Well, not much of a factual story to tell us in here, but there is a long and winding road of legislation and lawsuits. If you could maybe take us to the beginning and walk us up to where we are today.
In the beginning, there was no wrong story. Thank you so much. A happy Constitution Day to everyone. One of my favorite holidays. Although I think Constitution Day is unconstitutional. I think it's against the Constitution to mandate any institution speak on a certain issue. It's a violation of free speech. But I'm here voluntarily and not through the coercion of the state. So I'm happy to be here. The Affordable Care Act litigation has been going on for almost a decade. I've written now 2 books on this litigation, with a third in the works. Our story begins in 2010, when Congress enacted the Patient Protection and Affordable Care Act, also known as Obamacare. The Affordable Care Act had an important provision called the individual mandate. Now, the word individual mandate doesn't appear anywhere in the statute, but that is how this provision come to be known. The way Obamacare works is that people who want to buy insurance are able to buy it without discrimination. If you're older or sicker or having pre-existing conditions, the insurer cannot deny you coverage. And they also can't increase your premium if you are more costly to insure. This sort of protection, though, creates a risk. If I know that I can buy insurance at any point without having my rates increased, I may decide simply to go uninsured, risking it. And if I get sick, I go up and sign up for this healthcare policy. The mandate was designed to avoid this sort of free riding, what's known as adverse selection, where people can game the marketplace. So the mandate says you shall maintain insurance. Okay, and what happens if you don't maintain insurance? There's another provision of the law called the shared responsibility payment, which says if you don't maintain insurance, you have to pay roughly $700 a year, and that amount can vary. So again, one provision says you have to maintain insurance, and another provision says if you don't have insurance, you have to pay $700 a year. Okay. This law was challenged almost immediately after President Obama signed it into law. In 2012, the Supreme Court narrowly upheld the Affordable Care Act. Chief Justice John Roberts wrote the controlling opinion. And he said a few things that are important. He said, first, Congress cannot make people buy insurance, right? They can't mandate that you buy insurance. But the ACA could be read a different way. In many regards, the Affordable Care Act can be read not to mandate people buy insurance, but as a tax on the uninsured. Wait a minute, Josh, what's the difference? Well, as the law was drafted, it says you have to maintain insurance, and if you don't, you pay a penalty. Robert says you cannot do that. That's no good. You can't make people buy a commercial product. But he said if you read the law in sort of a different light, sort of shift it, you squint at it, you glance at it, right? You give a different perspective, it might look a little differently. And the law as a whole could be understood as simply taxing the uninsured. Congress's taxing power is much broader than its power to regulate commercial activity. So where does that leave us? The chief said, the law as written is unconstitutional, but I will save the law. I will give it a saving construction to uphold it. And he says, because this penalty resembles a tax, I can construe the ACA as a whole as imposing this tax. Okay. At the time, people were angry, they were sad. I wrote a book about it. That's what I do. Fast forward a couple years. In 2017, President Trump becomes president, and he makes the promise that he's going to repeal Obamacare. That was never a credible promise. It simply wasn't going to happen. There weren't the votes to repeal it. But what they were able to do was to reduce the penalty to $0.00. The penalty was now zip. The mandate wasn't touched. The Congress did not repeal the mandate. They simply reduced the penalty to $0. Again, these were separate provisions of the statute. Now, as soon as that happened, Texas and some other states said, the Chief Justice said that the ACA is saved because the penalty can be construed as a tax. It raises revenue. But the ACA no longer raises revenue. It raises $0. Therefore, the so-called saving construction simply doesn't apply anymore. And because the saving construction does not apply, we are left with an unconstitutional mandate to buy insurance. And if the mandate's unconstitutional, then other parts of the law have to go, or maybe the entirety of the law has to go. This is the issue that the Supreme Court will decide this term. Arguments will be held, I think, the second week in November, right after the election. That was timed quite well. I think that was deliberate. But this is a case of California versus Texas. Now, why is it California? The Trump administration has declined to defend the ACA. They agree with Texas that at least part of the statute is unconstitutional. They're a little bit vague over which parts. They don't like answering that question. They're sort of hedging on a bit. But California has intervened to defend the Obamacare law. This case will continue no matter what happens with the election, whether President Biden, Vice President Biden wins or President Trump wins re-election. This case will stay. This is a significant issue that will be argued next month or in November.
Professor Blackman, thank you, because it is a complicated story, and you gave it to us well. I would like to highlight one thing for our audience. Almost going back to the comment you said, hey, is Constitution Day itself constitutional? Could you give us the 1 minute overview on the notion that Congress and the federal government, the government of limited powers, and that the arguments listed here are based on this notion that health insurance mandates aren't in Article 1. How do we do this?
Sure. You are all in Kansas. I am sitting here in Texas. We have 50 states. In our system, the states have the first crack at doing stuff. The states have a broad power to protect the health, safety, welfare, and morals of the people. If you notice during this pandemic, almost all the health laws came not from the president, but from the governor. There's a reason. The states have primary responsibility for the health of people. They have lots of power. The federal government doesn't have that sort of broad power. They have specific powers that are listed in the Constitution. They're listed, they're enumerated, they're basically numbered right in the Constitution. The ACA case presented the question, is the power to make you buy insurance one of those listed powers? The states can make you buy insurance. Not much of an argument against that. I can make one, but not tonight at least. But there had never been a purchase mandate from the federal government. And that's why the Obamacare case was such a significant decision. Could Congress make you buy a commercial product that you did not desire? The state can make you wear a seatbelt. The state can make you buy insurance if you're driving a car. But can the feds make you buy insurance as a mere product of existing? That because you exist, you have to be under this mandate. And that was a question presented.
And that's why Chief Justice Roberts then, when he reframed a saving construction, reframed it as a tax penalty, because the taxation power clearly is part of Congress's powers, and now we've perhaps taken that away. I'd like to start, Professor Blackman, before we get into the pros and cons of this argument, a little detour into this concept of standing. And so for our audience at home, standing is a limitation on the power of the federal courts. And so the federal courts can only hear things of a judicial nature. And usually the court says, among other things, that you have to have an actual injury in fact. Here, the argument around standing is this: Congress has made the penalty, as Professor Blackman said, zero. So how are you harmed? Either you buy insurance that you want, or if you don't, you pay a penalty of zero. So where is the injury in fact that gives the courts power to decide this case?
Thank you. Here's another way that federal courts and state courts are different. In state court, you can bring just about anything you want. Any sort of dispute, you bring in state court. I know in your state you have this dispute between the governor and the legislature. Am I right? Was that Lou? Is that right?
That is
that would never fly in the federal courts, right? State courts can hear just about any case they want. Federal courts are more limited. They have what's called limited jurisdiction. The word jurisdiction is a fancy word that just means what kind of cases can a court hear. One of the basic limitations is that you can only go to court if you're injured, right? Has the government injured you? Maybe they've assessed a penalty or a fine. Maybe they've arrested you, right? Maybe they've enacted a law that regulates your business. When the government takes these actions, you're injured. You have basically a standing to sue, what's called standing. This case, the Obamacare case, presents an unusual argument for standing, and I admit it's unusual. But it's only unusual if you don't know the history of this case. The penalty was reduced to $0. If you don't want to buy insurance, you don't have to pay a penalty. So the argument goes, how can you be injured by a $0 penalty? If I go to you and say, hey, Professor Mulligan, give me $0 or else. Be like, okay. All right, thank you. Right, give me $0. Even if it was a penny, there'd be an injury. It's $0. Now, the answer to this question has to do with the way this case has been litigated before. I said at the outset of my remarks that the mandate and the penalty are different provisions. In the first Obamacare case in 2012, the plaintiffs did not challenge a penalty. In fact, they argued they would never pay the penalty. The penalty would only be assessed a couple years in the future. And in that case, the plaintiffs said, we are going to follow the mandate. We are never going to pay the penalty. In other words, in the first Obamacare case in 2012, standing injury was premised entirely on the mandate. The requirement to buy insurance was a pocketbook injury. I have to buy insurance. Or else what? The or else what didn't matter. What mattered was the requirement to buy insurance. If you don't believe me, maybe you don't know me, you can go back and watch the oral arguments from 2012. And Chief Justice Roberts and Justice Kagan were asking, what happens if a toothless mandate with a $0 penalty? They were anticipating this issue, right? So this has been vetted. I'm actually pretty confident on standing. We'll get to severability in a minute. That's kind of a train wreck. But on standing, I think the plaintiffs got it. This is a requirement to buy insurance. It's unusual, but I think it's an injury in fact.
So the idea here is that there's an injury not because of the penalty, but because of the requirement. Right. And it's the sheer fact that the government's mandating you, even if it doesn't have much of a stick or any stick at all, that the sheer mandate itself creates the injury. Well, let's move then to the merits, as it were. And so in some sense, the issue here is this still a tax? Or is it not a tax? A rose by any other name would smell. So is this a tax, constitutionally speaking?
Well, the Chief Justice wrote this very unusual opinion in 2012. He did not say that the ACA was actually a tax. If he said that, would be easy, right? He said Congress did not enact the tax. Rather, he said the law can be read as imposing a tax if certain conditions are satisfied. One of those conditions is it has to actually raise revenue. The core feature of any tax is it generates money for the government. As things stand now, the ACA does not raise revenue for people who go uninsured. There's no revenue being raised. I don't think the saving construction saves anymore. I think we're back to the ACA in 2012 without the saving construction. And I think the mandate's unconstitutional. Of all the questions in this case, this one's the easiest. I'll tell you, the state of California barely defends on this point. I think they'd be willing to say, all right, just say the mandate's unconstitutional, leave us alone. Let the rest of the law stand. There's not much of an argument. I think there's some I can raise, but this I think is one of the easier aspects of the entire case.
So in your view, then, if Congress had said there's a 1 penny
That's fine.
fine, then we would have raised some revenue, and that would then be a constitutional tax, and off the races we go. But because they went literally to zero, that's when it crossed the constitutional line in your analysis.
Penny saved is the penny earned. That will save the law. And in fact, if you want to get meta on me, I know you do jurisprudence. Let's say Congress restores the penalty tomorrow. The ACA becomes constitutional again. It's basically brought back from the dead. You have a zombie statute, right? But even if the court says it's unconstitutional, if Congress raises the penalty, it would resurrect. With that one for a minute, but I think it's absolutely the case. I actually call it Schrodinger's mandate, where it's both constitutional and unconstitutional at the same time. It's a sort of paradox of law. Welcome to John Roberts' world.
If I were to task you to give us the best argument on the other side on the tax, what's the best argument that this actually is still constitutional, even with a penalty of zero?
Yeah, it's one that I'm actually very nervous about. I think it's a good argument. Not everyone pays their taxes on time. People postpone their taxes, they delay them, they're delinquent. Even though the penalty was zeroed out in 2017, not everyone has paid their penalty yet. There's some people floating around the world, they exist, who haven't paid it yet. So if there's one person sitting in Lawrence, Kansas, who has not yet paid his penalty, and he decides to pay it next year, there's revenue, there's your penny. So this is one I've been dreading, because John Roberts likes to twist a knife in my heart every year. This is how he does it. It's like, well, there's a guy in Lawrence, Kansas, right, who hasn't paid it yet. So there you go. That's the best one.
Do you think that the court will take that much of a off-on switch as opposed to a dimmer switch, to use an analogy, approach to what a tax is? Or do you think there'll be that bright line about it?
Look, Professor Mulligan, the Chief Justice finds a way to disappoint me every year, and this is one way he could do it another year. It would not be the court; it will be him, and the other justices, they'll just go along with whatever he writes. Doesn't matter. They just care about the bottom line. So this is one that I'm like, oh, this is such a Roberts argument.
I have one or two more questions for Professor Blackman, but if folks in our audience want to send in a few more questions, please go ahead and do so while we go to our last topic to discuss, which is this idea of severability. So severability is the notion that sometimes a statute has, let's say, 10 parts, and perhaps part 7 is unconstitutional, but parts 1 through 6 and then 8 and 9 are constitutional. Do we just excise, like a surgeon, the one unconstitutional bit, or does the whole thing have to fall because it's all interrelated?
Yeah,
how does severability relate in this case?
Let me use a gross example. So let's say you have gangrene, right? And you have gangrene in your toe, your big toe. You might be fortunate, and they can just cut off the toe, and then you're fine. But sometimes the gangrene spreads to your foot, and they might have to amputate the foot. And maybe they have to amputate below the knee. And maybe they have to amputate the entire leg. And in some rare cases, the gangrene spreads and the patient's lost, right? The patient cannot be saved. That's basically how severability works in the Supreme Court. You have this infection, this unconstitutional problem. And the courts try and cut off as little as possible to save the body, to save the entire statute. But sometimes if this unconstitutionality spreads throughout, you have to cut off more and more and more and more. And if the infection is so wound up with the entire statute, you have to kill the law. There's a question I see in the chat from Kevin who asks, why couldn't the court have just sent the entire thing back to Congress for a blank slate? That's what the 4 dissenters wanted. They said, look, we can't carve up the Obamacare like a Thanksgiving turkey, You get some dark meat, you get some white meat, you get the leg. You can't carve it up like a taxidermist, right? We're not butchers here, we're judges. So just kill the entire thing, send it to Congress on a blank slate, and let them work from scratch. The chief did not do that. He saved it, but didn't really save it. He sort of just created a facsimile, a copy of it that exists in this alternate parallel Schrodinger's box where it depends on how much money is being raised. So we're stuck in this thing. So the severability analysis is actually really complicated because there's two Congresses involved. This is a mess. In 2010, Congress enacted the ACA, and in 2017, Congress enacted the repeal, the zeroing out of the penalty, the FONS A, right? The happy days are here again, right? The issue here is which Congress's intent controls. By 2017, people realized that the mandate wasn't actually that important, that you could have Obamacare without the mandate, you can just zero out the penalty. But in 2010, people thought that the mandate was the most important thing in the world. You couldn't live without it. And that if you didn't have the mandate, the entire law would have to go. So whose intent controls? If we look at the 2017 Congress, that suggests that maybe just the mandate goes. You just sever the toe and the rest of the body, sort of hops along. If the 2010 Congress controls, then maybe the entire patient has to go and you start from scratch. These are hard questions. I don't have nearly enough time to explain. Those are the rough issues.
What's your crystal ball prediction on severability? So we know where you stand on sort of the merits. You believe this is a pretty easy call, unconstitutional. Do you think they'll be able to conjure up a severability analysis, or the whole thing goes?
Oh, I don't think there's any chance the whole thing goes. I don't think anyone thinks that's going to happen. It's maybe there's 2 votes for that position, although I'm skeptical. The reason why is this is a law that's been in effect now for almost a decade. In 2012, it was kind of new, right? No one really knew what it was, whatever. Now it's a pretty big deal. So I don't think they killed the entire thing. I did an amicus brief. You mentioned amicus brief, Friends of the Court briefs. I did a Friend of the Court brief for the Cato Institute, which is a libertarian group in Washington, D.C., and we argue sort of a middle of the road approach. We say, well, the ACA's mandate's unconstitutional, and some of the regulations are unconstitutional as well, but you don't need to kill them for everyone, right? There's some people who like Obamacare and aren't claiming an injury. So maybe the court can say, if you like Obamacare and you go in the Obamacare marketplace, keep your policy, right? Keep your regulations. But if you want to buy a policy off the exchange in the private market, well, in those places, you're not bound by these regulations. And we crafted this argument with an eye towards His Glory, John Roberts, and Justice Kavanaugh as well, as perhaps a middle ground that you leave Obamacare in place for most people, but for those who feel an injury, those who feel injured by it, they would have an opt-out. That was the best I can come up with. The most likely outcome is the court says the mandate's unconstitutional, and we stop there. I get to write a book about it, and nothing in the world changes. This is basically how my life works.
But you still get to be a tenured law professor, so it won't be that bad.
I have the best job in the world, don't we, Lou? Isn't it?
Yeah, absolutely. Blaine asks, going back to your earlier prediction, but Blaine asks, the court or Chief Justice Roberts has gone through pains to uphold the ACA multiple times.
Yeah.
Is there really any chance the court or Chief Justice Robert flips in a meaningful way this time?
Pains, very painful, very painful.
Yeah.
Yeah, Blaine, I hear you. I think the chief will issue a decision that makes everyone angry. I think, we're taking a step back. We're talking a lot about Roberts. I think when John Roberts writes an opinion, his goal is to make everyone angry on both sides of the issue. If everyone walks away infuriated, it's a good John Roberts opinion. He does it every year. He did it in the DACA case. He did in the Little Sister of the Poor case. He does it just in the census case. Just everyone's always angry at him. And I think that's where he wants to be. He wants people just to be unhappy with him on both sides, so that we can say, see, look, I'm not pleasing anyone. I don't know. I don't think there's any chance he limits it, although the brief I wrote might give him an out that could cause minimal disruption, but still actually follow through in his opinion from 2012.
Well, thank you so much, Professor Blackman, for your discussion of that case, and we'll look forward to seeing that decision, and then in a couple of years, reading your next book on it. Thank you so much.
Thank you.